Amazon top 5 bestseller and a great resource for me while I was outlining.
You're welcome.
And finally, he can be found blogging at the Bala Conspiracy and tweeting at Josh M. Blackman on Twitter. And just to quickly introduce Professor Greenfield,
He needs no introduction.
he is our BC Law professor and Dean's Distinguished Scholar here at BC. He was a clerk for Justice Souter and has been featured on outlets such as CNN, MSNBC, and Fox, as well as the New York Times and the Washington Post. He has written over 4 dozen law review articles and multiple amicus briefs for the Supreme Court, as well as authored Moore's Federal Practices on the Supreme Court. And his latest book is Corporations Are People Too, and They Should Act Like It. We look forward to welcoming them both to speak, and thank you very much, gentlemen.
Thank you so much. I love coming to BC because my good friend Kent is always willing to come to a FedSoc event and talk about these issues. It's not always the case at other schools, so he models, I think, the best professionalism and collegiality in academia. So thank you to Kent, so David, a few others. Good to see you all. He's going to dine and dash, grab the barbecue, and go. I know it. So we had a huge term last year at the Supreme Court. This phrase, unprecedented, is often thrown around a little bit too easily, myself included. But this term really was unprecedented. We had landmark decisions on abortion, guns, religion in the span of about 72 hours. In a very short period, the court changed course in a number of very contentious issues. So that's what I want to focus on today from last year. Abortion, guns, and religion. All right, let's start with abortion. I'm sure you've all, how many of you taken con law yet? Okay, almost every hand, good. So I'm sure you've all studied Roe v. Wade and Planned Parenthood versus Casey. These were the controlling abortion standards for about 5 decades. And under these rules, as they stood, you could not prohibit abortion prior to the point of viability, which was 24, 25 weeks, 26 weeks, depending who you ask. Mississippi enacted a prohibition on abortion at 15 weeks by any measure that is prior to the point of viability. Now, why did they enact this obviously unconstitutional law? They were trying to create a test case, a vehicle to overrule Roe and Casey. And indeed, in the span of a few years, we have 3 new justices. Justice Scalia was replaced by Justice Gorsuch. Justice Kennedy, the swing vote, was replaced by Justice Kavanaugh. And Justice Ginsburg, the stalwart of the court's progressive wing, suddenly passed away before the election. And she was replaced by Justice Amy Coney Barrett. So it was once a 5-4 court that leaned conservative-ish, liberal-ish, depending on the breakfast of the day, was now a solid 6-3 conservative court. And the first big mark they would make would be on abortion, because the court agreed to take Dobbs versus Jackson Women's Health. This was a ban on abortion at 15 weeks. Now, there are a couple ways to look at this case, right? First off, was Roe correct as an original matter? Even in Casey, his former boss, Justice Souter suggested that maybe Roe was not correct as an original matter. But there are other reasons for maintaining the decision, one of which is something called stare decisis. This is a phrase that means you stand by the decisions of the court. Another concept of one of legitimacy. Justice Souter and O'Connor and Stevens wrote in Casey that it looks really bad when the court changes its direction simply because there are now more conservative judges on the court. So even if they may not agree with the Roe decision in the abstract, right, it was correctly decided, there are rationales to keep it, or at least keep something looking like Roe. They kind of modified and tweaked around the edges a bit, but at least keep the core holding of the Roe decision in place. This past term, the Supreme Court said, nope, we are not going to do that. And they made this point in several very, very clear ways. So first they said Roe was wrong the day it was decided. It was egregiously wrong. And the principles of stare decisis do not justify keeping Roe in place. Justice Alito said that this decision has created confusion in the lower courts, has created a lot of instability. And also he said there's no reliance interest, which is very much at odds with what Casey held. Casey held that an entire generation of women had come of age relying on the Roe decision. And Justice Alito said that's not how we do reliance. Reliance is about property and contract interests, not on some sort of a hypothetical need of a person for an abortion. Okay, what about legitimacy, this other concept the court came up with? The Casey court was very much concerned with how the public would perceive a decision reversing Roe. In dissent in Casey, you have Justice Rehnquist and Justice Scalia saying it's not the business of the courts to bother themselves with public perception. In Dobbs, the court said, we don't care what you all think. Maybe they do care, but they said they don't care. They said it's not our concern. It's not our business to worry ourselves with public perception, the national psyche, they call it. This is a very unclear method of deciding cases. All right. The dissent in Dobbs was written by Justices Breyer, Kagan, and Sotomayor jointly. And they worried that this decision would undermine the court's legitimacy, that it would taint or tarnish the court for a generation to come. You have Chief Justice Roberts, who didn't join the majority. He didn't vote to overrule Roe. Instead, Roberts sort of made up another test. He said, well, there is a right to abortion, but Roe is not necessarily right. But 15 weeks is enough, right? At 15 weeks, you've had enough notice to get an abortion. If you didn't, that's on you. Kind of made that up, all right? So the abortion decision has had, I think, significant political fallout. Maybe Kent and I will talk about this as well. We've already seen referendums in Kansas and other states where abortion votes haven't been going the way conservatives may have expected. For generations, Republican politicians could just pass abortion laws without any consequence because they would never go into effect. But now when these laws will actually go into effect, I think there'll be electoral consequences. So in at least one regard, the Dobbs decision restored to the democratic process a very contentious issue. And I think politicians will in some cases pay the price for passing laws that the electorate doesn't care for. Now, the next case is sort of the opposite. In the Dobbs decision, the court said, abortion is for the political process. The next case, the court said, guns, that's for us, right? So I'm speaking now of New York State Rifle and Pistol Association versus Bruin. This case considered whether the Second Amendment protects a right to carry a gun outside the home. D.C. v. Heller was a landmark Second Amendment case that concerned keeping a gun in the house. Didn't talk about carrying. So a decade after Heller, we finally get to Bruin. And the question is this: is there a right to carry a gun outside the home? Or more specifically, can the government make you justify why you need a gun outside the home? Okay? Can they make you justify that decision? In New York and Massachusetts and a few other states, if you wanted a concealed handgun license, you must show what's called proper cause or good cause, a special reason why you need this license above and beyond the usual justification. It's not enough to say, I have self-defense needs. That's not enough. You have to have something special. Okay? Massachusetts required more. In 43 other states, like where I live, there's no need. As long as you pass a background check and show you don't have a criminal history, you will get your license. All right? So this case comes to the court. And here the Supreme Court says that, number one, the Second Amendment guarantees this right to bear arms outside the home. And that wasn't really in doubt. But then they say this subjective test where you have to show proper cause is too much. And the court found this was unconstitutional. Justice Breyer dissented. He also wrote the dissent in Heller and in McDonald. And Breyer said that this is a travesty that we are now telling local jurisdictions that they cannot select the policies that fit their needs with regard to gun violence. Indeed, there was a mass shooting on the New York City subway several months before the Bruin case came down. So now in the wake of Bruin, we're having a lot of decisions involving what kind of tests can be required. So New York is trying something funny. They're trying to say, well, okay, we can't require good cause, but we can require showing good moral character. You have to show you're a good person. And also, by the way, you have to submit your social media handles so we can look at your tweets and see if you had anything negative in your social media. This is not going to work. This is an area where the First and the Second Amendment will clash. I don't think that this will be acceptable. All right. What's a sensitive place? New York City decided that Times Square is a sensitive place. Now, not like a 5-block area. A 35-block area in central Manhattan is now off limits to guns. They may have overshot. That may be a little bit too broad. What about different types of weapons? So-called assault weapons, which is a fancy phrase for meaning guns that look scary, right? Will assault weapons now be protected? What about for non-violent felons? This is not an obvious issue, right or left. There are lots of people engaged in, say, white-collar offenses who show no propensity for violence. Why are they disarmed for life? Is there a historical tradition of banning such people for life? Another issue that might come up even is involving serial numbers. A court recently found, which I think won't stand, that requiring guns to have serial numbers might be unconstitutional. I think that's probably a bit misreading of the Bruin decision, but we'll have a lot of cases. All right, so I did abortion, I did guns, let's do religion. 3 religion cases, all with a common theme. I'll start with right here in Boston. So Boston City Hall has a flagpole. Anyone ever see City Hall? You been there? Big flagpole right in front. And the government has a policy. If you ask to have your flag raised, they'll do it. And for a number of years, many flags were raised for sports teams, for foreign countries, and any flag they would raise. Except one day, a Christian group came along and said, we want to raise a flag with a cross on it. And the government said, no, that'd be an establishment clause. Separation of church and state, we're not going to raise your flag. So then the group sued. First Circuit upheld it. But then the Supreme Court reversed 9-0, an opinion by Justice Breyer. This is not one of these 5-4 cases. This was a 9-0 case. And the court said this was viewpoint discrimination of a sort, right? That they were targeting this group because of their Christian messaging. What about the Establishment Clause? The court said merely raising a flag with a cross would not be enough to trigger the Establishment Clause. So again, pattern. You cannot violate free speech to avoid an Establishment Clause violation. The court says you can't do that. Next case from our friends up north in Maine, Carson versus Macon. Maine had a program where they would provide funding to private schools if you lived in a very isolated area, except if the private school was religious in nature. They would not provide funding for these schools. Why? Maine said, were we to provide funding for these religious schools, we would violate the separation of church and state. We'd be entangling ourselves with religion. We're going to keep money away from these churches, these religious schools. So some parents sued, saying you're violating our First Amendment exercise rights. What happened? You guessed it. The Supreme Court said you cannot violate the First Amendment to avoid an Establishment Clause violation because providing this money would not violate the Establishment Clause, sensing a pattern here. And in this case, this was not a 9-0 case. This went 6-3. The court's conservatives said that you actually had an obligation to fund this religious school. Now, Kent will probably agree with me. 30 years ago, maybe 40 years ago, the court said the opposite, that it would be unconstitutional to fund these schools. And now they're saying the Constitution requires you to fund these schools. He's nodding. If you can't see, he's nodding yes. Okay, we agree on things, right? So that was actually kind of a stark reversal from 40-odd years ago, from the 70s and the 80s. All right, I told you 2 cases. Now the third one is the big one. Coach Kennedy. Kennedy versus Bremerton School District. Kennedy was a football coach. He was actually an assistant football coach. He was not the head coach, but it's all good. He was an assistant football coach out in Washington, in a suburb of Seattle. After games, he would do something. He would go to the 50-yard line, he would kneel, and he would pray. Sometimes he prayed alone. Other times he prayed with others. So some of his own players came along. Sometimes players from the opposing team came along, and they all kneeled and they prayed with him after the game concluded. The school district said, hey, coach, no, you can't do that. Why? It would violate the Establishment Clause and the separation of church and state. You're sensing a pattern, right? They said, you can't do that. So then he sued, saying you're violating my free speech rights. So again, it's a situation where the government says you cannot exercise religion, you cannot speak about religion, and then they go to court. All right, this went to the court also. 6-3 again. The Supreme Court said the coach wins, and the reason why is significant. Here, the court effectively overruled a case called Lemon versus Kurtzman. Lemon was a case from the 1970s, which said you cannot have an entanglement between government and religion. You can't have this excessive entanglement. The Lemon test was around for about 40 or 50 years. It's a very well-established test, but it's proved very unpopular among conservatives. Now, I say effectively overruled because they didn't really overrule it. They said, well, we've abandoned this case. We've abandoned it, whatever the heck that means. But they told the lower courts, hey, you guys, don't rely on the Lemon test anymore. You idiots, right? Get the picture. This is Gorsuch talking, right? Just stop it. So because the government screwed up, they then had to allow the coach to say the prayer at the 50-yard line. Again, 40 years ago, it would have been unconstitutional to allow the coach to say the prayer at the 50-yard line. Today, the Constitution requires allowing the coach to say the prayer at the 50-yard line. So in these 4 or 5 cases I just mentioned, we have really 180-degree turns from the 1970s and 80s, right? Roe v. Wade, gone. Lemon test, gone. In the span of 72 hours, right? I mean, it happened, it's a commercial, life comes at you fast, right? Life comes at you fast in the Supreme Court now. And it's sort of, I think, difficult for, your 2Ls and 3Ls. You took common law last year. That's nice, right? There's a lot of change. Sorry, that was mean. I think I write about this stuff. Kent writes about this stuff. A lot of stuff we wrote doesn't really have relevance anymore because it's been sort of obviated by the passage of time. I mean, I read a common law case book. I have you mentioned my book. I have 100 Supreme Court cases everyone should know. Go buy a copy. A new edition is coming out in November. And we have Dobbs and Bruin and Kennedy. We added those over the summer on very short notice to make sure we're up to date. All right, so I think I did abortion, I did guns, I did religion. I did all the good stuff from last term. Now my good friend Kent will come up and he will talk about some of the decisions that are coming up the current term that began a few weeks ago. So thank you so much for your attention. Lawyers Kent.
Thanks, Josh. It's always a pleasure to have you here. Thanks for coming up from Texas to uh, enjoy the New England fall.
Foliage is nice. Weather.
Yeah. So let me talk a little bit about the last year, just for a couple minutes, the state of the court, and then I'll flag a few cases that we should all be looking for in the coming months. In terms of the court in general, I think one of the things that's happening or has happened over the last few years, I think the court is a different institution and has a different role politically, I think, in America than it did even 10 years ago. One of the reasons for that is I think it's the court is much more ideologically predictable than ever before. You now have 6 justices appointed by Republican presidents, and they vote conservative. And you've got 3 justices appointed by Democratic presidents, and they vote more liberal. Now, as recently as 10 years ago, you had justices who had been appointed by Republican presidents who voted liberal. Sometimes you get justices appointed by Democratic presidents who vote more conservative. Byron White, for example. My old boss, Justice Souter, was more on the liberal side of the court. And so, but what we have now, you have the ideological camps pretty well set out, and the outcomes, you don't see outcomes like you did in Casey from 30 years ago, where the 3 justices who wrote that plurality opinion to save Roe for 30 years were all Republican nominees, Kennedy, Souter, and O'Connor. The other thing to notice, I think, about the court is that the court, and Josh and I were chatting about this before, the court, I think, is because of its supermajority of conservatives, I think the court is sort of feeling its oats. It's the Leah Lippman is calling it the YOLO court, right? It's the you only live once court, and they're being really aggressive. They're being aggressive on abortion. They're being aggressive on religion. They're being aggressive on guns. The administrative state, something that Josh is also a really important case from last term, West Virginia v. U.S. And I think this term now will turn to race, discrimination law, and election law in ways that I think are pretty ideologically predictable. the other thing to say, I think, is that one of the interesting things to watch for this year is that for the first time in history, all the liberal justices are women. So you're going to have it's going to be interesting to watch the dynamics of the arguments, the life within the court to the extent that we can intuit it from the outside. That's never been the case. And also, the Solicitor General of the United States, Elizabeth Prelogar, is a woman. So you have, and she speaks for a more liberal administration. So you have the four liberal voices on the court being female voices. So that's never happened before, and it's going to be interesting to watch. Um, in terms of, and I think one of the ways that you can see the impact is Ketanji Brown Jackson, even though she's the most junior justice in the court, she's already been very active in arguments, especially in the Alabama case from a couple of weeks ago, where she was the most active justice. She gave a history lesson during the oral argument about the impact and the intent of the 14th Amendment. And I think her role in the court will be material, at least with regard to the arguments and what's taking place in the arguments, what's taking place in the discussions. Um, I think the other thing to notice about the court, and I think this is a reflection of the YOLO conservative aggression the assertiveness of the court, is the court's willingness to manipulate or make exceptions to what has long been seen as procedural guidelines that the court has taken. It has taken cases like the West Virginia case last year, cases that would not have usually been taken because they weren't really ripe, or they had the West Virginia case struck down a rule that was not in operation. And so the usual notions of we're not going to assert our views of this unless it's a live dispute was waived in that respect. I think the Kennedy case is another example in which the court, I think it's pretty fairly said that the court's manipulation of the facts were pretty obvious. Gorsuch, in his opinion, talks a lot about how this coach, was praying quietly on the sidelines. That wasn't it. I mean, Sotomayor in her dissent, like, puts a photograph of the coach kneeling at the 50-yard line as calling Gorsuch's opinion to task. And then I think another example is a case that's coming up this fall, the 303 Creative case, which is the case that is again challenging Colorado's anti-discrimination law as applies to corporations and other businesses. And in that case, the court, the business at issue is a web design company, and the web design company claims that it wants to produce wedding websites, but doesn't want to do it for same-sex couples because it's against the business owner's religious beliefs. But the business is not really in operation. The business has never produced a website, and so in normal rules of ripeness, mootness, one would have thought that one would have waited until you had a live dispute, but the court sort of took cert on the case anyway. Now, that's table setting. In terms of what to watch for in the fall, I think we've got a few sort of categories of cases to look for. I think the big thing is race. Last year was abortion, guns, religion, administrative state. This year, I think the central question is going to be race, and there are three cases that put race at front and center of the court. One is the Voting Rights Act case from Alabama, Merrill. There's another big case called Moore. So it confuses those of us who try to keep track of cases by their first letter. So the Merrill case is from Alabama. It's the Voting Rights Act case. And there, the challenge is to the congressional districts created by Alabama. And the Voting Rights Act explicitly allows the use of race in constructing majority-minority voting districts, as long as they're not the dominant reason for creating the district. And I think, so that's one case in which the use of race, the question of use of race is made explicit. You've got the affirmative action cases from North Carolina and from Harvard, in which it asks whether it is consistent federal law, constitutional law, and also statutory law. Whether any university, even in a holistic manner, even in an individualized manner, can use race at all. And I think it's pretty clear. Most court watchers predict that the court will strike down the use of any use of race in college admissions. And I think then there's another case that, unless you're a big court watcher, you may have missed already, but there's a case that concerns the Indian Child Welfare Act, ICWA. And in ICWA, there's a preference for the placing of foster children, to give foster children to members of tribes, uh, preferably members of the tribe of the Native American child. But if that's not available, then another tribe. And so I think the case will raise the question of whether you can be attentive to membership in a tribe. And I think it's totally possible that the court will strike down that provision of ICWA as violation of equal protection. But I think race is front and center in those three cases. There's also two other cases that are being argued this fall. They haven't set the spring docket yet. But the two other cases in the fall that are really important: the 303 creative case, which I referenced, the question of whether a company can have a First Amendment right to discriminate if if the customer embodies something that is contrary to the company's religious beliefs. Um, uh, and the other case is the Moore case out of North Carolina that raises the question of the independent state legislature doctrine as to whether state legislatures in elections, in the context of federal elections, have sort of unreviewable discretion to determine, dictate, even adjust uh, rules of elections, and that if the court ends up validating the independent state legislature doctrine, it could have a material impact on the next presidential election, without a doubt. So I think those are the things that I would flag going forward. And I do think that I think the thing to say is, and this is a good prompt for us to sort of go on from here, Josh. The question I asked you before is whether you think, because of the ideological sort of YOLO nature of the conservative bloc, whether and you guys are the law students here, it strikes me that there's sort of the level of cynicism about the court is probably at its highest that I've ever seen in classrooms. And I've been teaching for over 25 years now. Um, and it strikes me that the question is whether the court has overplayed its hand in a sense. If and in one way, where we are is like a success of sort of a movement lawyering, over the movement, sort of conservative lawyers, law professors, students, advocates, judges, over the course of a generation, has really built up a sense of jurisprudential methodologies and beliefs and practices, and populated the courts in such a way that they've achieved success that is shocking to those of us who are court watchers. And I guess the question is whether they've overplayed their hand in such rapid fashion that if the overall goal is to convince this generation of law students of the benefits or the values of originalism, of textualism, of judicial restraint, that this generation of law students are just not going to be persuaded by that at all, and will instead see the court as a merely political institution rather than an institution that's governed by logic, persuasion, and argument.
All right, thank you so much. Thank you. So I think I agree with just about everything Ken said. I look at things a little bit differently. I've been teaching common law for only 10 years, not 25 years, but about a decade. And I've often had trouble teaching these cases for different reasons. When you get to Roe, it's just sort of, well, there's a right in the Constitution. Well, we won't really tell you where it is. Might be the Ninth Amendment, might be the 14th Amendment, potato, doesn't really matter. Then we get to Casey, we talk about the sweet mysteries of life. And we talk about Lawrence, where we have the dignity, this concept of dignity. Then we have a Bergefell, which is a due process, equal protection. We have Windsor, this kind of just merges the two. And I've always thinking, what is the doctrine? What is it that gets us to these various Anthony Kennedy opinions? And I would often just say, YOLO, whatever, right? You got 5 votes, doesn't really matter. Then don't sweat the details because we got the votes. And the response to Kent is, it's our turn now, right? In other words, the other side had their turn for several decades, and it was, very successful. And the conservatives sort of threw their hands up. And now I think conservatives are doing sort of much the same. Now, I think there is some constraint, and I have this debate all the time. Does originalism constrain judges? And I do think it does. I think even if you're Clarence Thomas, if you're Justice Scalia or Justice Gorsuch, there are some things that you might want to do as a conservative that you just can't do as a judge. There are also some things that you don't want to do that you will do. One example is criminal procedure. Justice Scalia, now Justice Gorsuch, are actually very strong on the rights of the accused. I think they actually look to founding era practice to justify those things. But I mean, I'll just give you just a horror hypothetical. Imagine instead of having 5 self-proclaimed originalists, you had 5 conservative living constitutionalists that just said, we are going to interpret the Constitution in the spirit of conservatism and what we view as the common good. This is the Adrian Vermeule school of thinking. Sorry, I knew he said Harvard. If I mention his name, he'll appear like Beetlejuice, right? Vermeule, right? He'll just pop in. Would you rather have 5 Clarence Thomases or 5 Adrian Vermeules? I'd rather have 5 Thomases. Maybe 5 Adrians. I don't know. That'd be hilarious to watch on Twitter, right? But I think originalism does provide some constraint. Now, whether they're moving too fast, that I think is a valid concern. There are always reasons to move incrementally. So with abortion, perhaps they could have said here, well, the 15-week ban is okay, but maybe we'll leave Roe in place for now. And then maybe 5 years later, you have like a 6-week ban or something else. That might have been how they did it in the past. But I think the court conservatives are saying, what we've been waiting 50 years, right? What else are we waiting for? Now, what matters, though, is what you all think. And I'm eager to hear your questions and answers. Right? If we do have a generation of law students that come of age and become very cynical of the court, which I think is the word that Kent used, that does trickle up. And I think over the long run, the court may decide, oh boy, maybe we went too fast, right? Maybe they pumped the brakes a bit. So we mentioned the independent state legislature case. I don't think that's going to go all the way. I think if anything, it might be a very narrow win for North Carolina or the North Carolina legislature. The Merrill v. Milligan case, the voting rights case, that one also, they might just modify the jingles. We didn't even get to the thing. They might just modify jingles. I'm not sure how far they go. The ICWA case, that's a hard case. It's so complex. I'm not sure what they're going to do there. But I think this term will be a little bit less whiplash than last term. We didn't mention affirmative action, right? That I think is the biggest case that affects us and you all. Is to what extent can public and private universities consider race in higher education admissions? That's a huge case with sweeping implications. Yeah, I think I agree with most of you said. Just I'm not so troubled by it. Maybe because I like what's going on, and I didn't like what happened before. But I think we all like to we all like to gore our own oxes every once in a while.
And my students will know I'm no fan of Kennedy's of so-called logic in those cases. The mystery of the universe is not the way you decide these cases.
Yeah.
But and also, I mean, I guess and just my last comment. I think there's another choice. The choice of 5 Thomases or 5 Mules. The worst case scenario is 5 people who claim they're Thomases but are actually Bermudes.
Yeah, I thought you would say that.
Right?
Yeah.
And use the use the patina of originalism to really do what they're wanting to do. And I think Bruin is a good example of that. As the original view of the meaning of the Second Amendment, Adam Winkler would say that it allows for robust and persuasive regulation of guns and gun ownership. But Thomas, sounds like an originalist, but mostly makes it up.
All right. I'll Ken have the last word. All right. Who wants to make up a question now? Let's hear from Suze. Oh, I want a student. Okay. All right, fine, David, fine, go
I
ahead.
have to read the class.
Professor Olson, go ahead. I'm sorry.
So I think the issue of cynicism is very important. Obviously, we don't know where the point is, but eventually, if we get to everyone cynical and thinks judges just do whatever they want, then that becomes a self-fulfilling prophecy. What person is not going to become a judge? It's collective action. So I think that's really important. So two-part question. One, to what extent are law students coming in incredibly cynical about the court versus to what extent are they picking up and reflecting back really cynical statements from professors right now? Second part of the question is to what extent, if we say the judges' decisions are aligning more one side Republican appointee, one side Democrat, is that to do political outcomes, or is it because for a lot of years there was kind of a broad consensus or lack of big dispute about judging, and over the years liberalism really comes along, that gets associated with one party, and so they have a set of principles and et cetera that people on Democrat side don't like, but that they're applying right in a principled way. And one maybe example would be pushing back against this pure politics is, all the election cases, all the ways to keep Trump in office and get even more conservative judgments, maybe, right? Trump just lost all of those cases, many of which were from judges that he reported.
Okay, so there's a lot there, and I'll of course, Ken, you can, okay. So look, law professors tend to skew left. I don't think I'm making an exaggeration when I say that. And a lot of them are very unhappy with what the court's done in recent years. And I do think that cynicism in podcasts and elsewhere does spill over into what law students learn. But if we just look at, Dobbs just for a minute, I'm a little bit conflicted on Bruin, but just to look at Dobbs for a minute, that decision, as unpopular as it was in some quarters, created a lot of democracy. It created a lot of legislation. And I think we're going to see the equilibrium change on abortion. I think states, these absolute bans will not exist in a lot of these states. I think people have second thoughts about them. Alito, at least in Dobbs, not in Bruin, but at least in Dobbs, saying you guys govern yourselves. And I think that's an idea that some people will have to learn. People on the left will have to see the court is not this font of progressive justice anymore. And if you want to have change, you can't go to the courts. In fact, keep it away from the courts. Go to the elected branches, right? Go to your city council, go to your town council, go to your state legislatures. That's not a bad lesson to learn. It's hard, but I think we're seeing it. Now, to the second part of your question about, where are we sort of headed? I don't know. I don't know if maybe Kavanaugh and Barrett made it. Okay, we've had enough. You guys got abortion. Let's just pump the brakes for a few years. I don't know what comes next. Kent, I don't know what your thoughts are there.
Yeah, it's interesting, David, what you're saying about cynicism. My sense is that when I'm standing in front of my students, that there's more cynicism in front of me than behind the podium.
Hmm.
But because I've got a vested interest in it being about logic and persuasion and argument, because that's what I do. I don't. I mean, I'm not a political science professor, but I think we're in a moment where I think we're just trying to come to terms with what the court is like. And I completely agree with Josh that the left is going to have to start depending on the Democratic branches. But the problem with that, of course, is that when we talk about rights, we shouldn't have to put the rights to a vote, whether it's and the right of the more conservative citizens believe that's true about gun rights and religious rights, and the left believes that about abortion and election and the like. So I think always the tough line is, where is that? How do we define those rights? And I'm not happy about Kennedy's the meaning of the universe, but I guarantee you I'm not happy either about trying to divine what James Madison would have wanted for marriage equality. It's just not relevant in my own. Even if I were a judge, how I would determine that case.
Okay, actually a student question. All right, so one right there. White shirt.
Thank you.
So you talked a little bit about originalism. I guess the question is, and I see this a little bit in moral arguments around the voting rights case, that nothing just almost making them feel to originalism. Saying, look, the body is that full rights of original intent was to actually consider race strongly, right? There's other Harvard admissions case where, there's the same challenge, right? Basically, like, conservatives are the ones who are saying, like, we're kind of going to deviate from the original intent. We're going to say, like, been there, done that. We did civil rights stuff. That's fine. Do you think that there's space for originalism on the left?
Okay, we'll do this one.
We have Jackson saying,
Right.
left, textualist, and her, front of the Senate. Is that a direction you think that those justices might try to take, at least when it comes to the right
Yeah.
stuff?
Again, it's a good thought. I do think, when we talked about this in common law, I do think there's a much broader basis for originalist arguments within the 14th Amendment context, because the folks that drafted, ratified, argued in favor of the 14th Amendment were pretty radical people. There's only so far you can go with that. Like sex equality was not within what they were thinking of. But I do think it's especially powerful with regard to race, and I think Justice Jackson made that point. And whether that's instrumental in her view, trying to get a Barrett or Kavanaugh or maybe a Gorsuch to sort of switch over, I do think that as a as a sort of political sort of institutional matter, it would be I mean the conservatives would would protect themselves from a lot of potential um, political backlash if they just went that way in a case like that, in the voting rights case, saying yes, race is okay to use because of original intent, and that would it would deflate the balloon for court reform like that.
You think that would work?
Well, I do think that if that I think yes, in a way, like if you had more cases like Bostock, where Bostock is the case where Gorsuch reads Title VII, the sex discrimination language in Title VII to include
Mhm.
discrimination on the basis of sexual orientation and gender identity. And I think if you had more cases like
Yeah.
that, or more cases like this, the criminal procedure cases where the originalist outcome is a more liberal view, I think it would shift this debate and make it seem less cynical.
Yeah. I'd like to add, yes, right over here.
The one question that I had is, you talked a little bit about Gorsuch sort of switching sides and voting with liberal justices in cases like Bostock. Are there any indications on whether Justice Tony Barrett or Justice Brown Jackson might do the same thing in other areas?
Look, I don't know where Barrett is in affirmative action. None of us know this. I mean, she was a law professor for 15 years. We deal with affirmative action every facet of our jobs. She has 2 adopted Haitian children. I don't know her views on race. I don't presume to think that she's Clarence Thomas on race. I just don't know.
Yeah. We will in 6 months or 8 months.
Yeah, right over there.
Hi, I'm just curious to hear Professor Greenfield's response to the idea that the last 50 years has been some sort of progressive win streak.
Yeah, I wouldn't put it at 50. I would put it at 15, maybe, between 1954 and 1969, maybe extended to 1973.
You got a good run.
Under Roe. I mean, you basically had the Warren Court.
Yeah.
Right. But both before the Warren Court and after the Warren Court, I think the Supreme Court has been more of a defender of existing power relationships and power structures. Railroads win, Native tribes lose, and so you've got you've got aberrations here and there, but 50 years ago, the court was one vote away from identifying education as a fundamental right, wealth as a suspect classification,
Right.
and now, like, would there be a vote for that on the court? Probably not. The
Not
Overton
one.
window has completely shifted.
Yeah.
So I do think that, and this is I do think we were I mean 16 out of the last 21 Supreme Court nominations appointments have been from GOP presidents. GOP nominees have won the popular vote once in 30 years. So I think the court is out of step with where the country is ideologically, sort of in general. So I think that and if Merrick Garland had been put back in the court, we
Yep.
would have been much more sort of aligned, I think, with where the country is, sort of a slightly left of center purplish country. But I think the court in this respect right now, especially 63, is pretty out of sync with popular sentiment.
Yeah, right over there.
I know this isn't coming up this term, but I wanted to ask what Barrett's president for death penalty cases coming up. I know she sided with the liberals
A
recently.
number of times on very shadow docket cases, she's voted to stay executions. Again, I don't presume that Barrett is the same place as Thomas on the death penalty. I think she's already signaled that she has apprehensions and misgivings about it. I mean, she's written about the death penalty as a Catholic in when she was a law student back in the day with John Finnis. Was it Finnis? No, it was the other one.
I don't know.
It was Garvey.
Sorry.
The other one. No, I can't. There'll be a nun who will wrap my wrist in a minute somewhere on campus. But yeah, she. That's what happens to the nuns wrap wrists, or no, that doesn't happen here. But I don't know where Barrett is in the death penalty. She may not be as strong as Alito and Gorsuch. So, there still might be a fourth, fifth vote to be had, even with a 6-3 majority every now and then. It's not going to be monolithic. Yeah, in the back, last row.
And I've heard that a lot, where it's just, it's not the court's responsibility to like go to vote and things like that. And kind of also addressing cynicism, I guess, where my cynicism lies is when that argument is perpetuated. Also, at the same time, the courts choose not to ruling on like gerrymandering cases. And so as the country becomes more and more gerrymandered, it's harder to actually believe that your vote is going to be counted properly. And then they're dismantling the Voting Rights Act. So we have a North Carolina case coming up where previously they said it's not our job to get involved with political gerrymandering. So how do we square away on the one hand saying, oh, it's up to the Oregon, it's up to legislation, but on the other side, they're also putting their thumb on the scale of that and limiting.
No, it's absolutely a fair point. So the gerrymandering case, a case called Rucho v. Common Cause, the court said we will not review gerrymandering. That's up to the state courts. And now in the follow-up case, Moore versus Harper, the courts can say, can the state courts even address gerrymandering? I'm not gonna challenge the premise of the question. In some cases, the court's saying we're not going to get involved with either voting laws or redistricting maps to make it harder to be representative. I think that's a bug in democracy in general. Gerrymandering is very old. It's been around for a very long time. And I think if you have enough political pressure, even in a state, I mean, look, I live in Texas, which is a fairly conservative state. Within the span of a few years, it's feasible that a Democrat may win the governorship, right?
Not this year. Not this year.
Possible.
Yeah, but
Unlikely. So I don't think that votes are fixed forever. So I think the response to your question is on the time horizon, immediate change may not be possible in some jurisdictions, but it does happen over time, which perhaps is not satisfying. People want no justice, no peace right away. I think when you don't have a Supreme Court saying I will issue from on high, it sometimes takes time to make changes, and that's not always reassuring people to hear. I'm sorry. Yeah, right there.
First, Bruin, what do you think compelling cases would be?
I don't know that Bruin attacked the compelling state interest prong because that scrutiny doesn't really matter, right? What Bruin really said was you have to identify some historical analogy, some regulation in history that's very closely linked to what you're doing now. And speak of the thumb, as the student just said, the thumb is on the scale of there's not going to be a historical analog, which would mean there's more latitude there's less latitude for the state to regulate guns.
Well, just as an aside, one of the things our friend Adam Winkler wrote a book a few years ago called Gunfight, and he does this deep dive into the historical data, historical record of what kind of regulations. And one of the things that happened all the time in New England towns, that anyone who owned a gun was forced to muster in the town square to allow the town masters to inspect the gun, and so the way to test Bruin is to have Newton say, if you own a gun, you've got to show up on the town green on
like
Tuesday and show all your guns and submit to an inspection, because there's a direct historical analog. And if people,
has anyone proposed that, Ken?
I just did. No, yeah,
I would love to see a bunch of people carrying rifles in Boston Common. It would freak the hell out of people. That'd be,
right.
That I would actually pay to come watch that. Yeah. Yes, ma'am, right over there. My good friend Steve Vladeck wrote a book on this. Good for him. I think the topic is overblown. I mean, transparency. Okay. I mean, the briefs are public, the opinions are public. There's nothing hidden. So I think what they're saying with the transparency is there's no oral argument. Okay. You don't always have a fully reasoned decision. Okay. Well, I mean, look, oral argument maybe makes a difference sometimes. Maybe makes the lawyers feel better. I don't know how often oral arguments actually matter. I think you can actually lose a case at oral argument. It's hard to actually win a case at oral argument. In terms of the short opinions, I'll just sort of give a contrary take. When the court's deciding issues on a very short fuse, there's a risk of setting a long-standing precedent, right? So sometimes these short orders that say very little are actually beneficial. Now, the flip side is some courts treat these sort of summary orders as if they're precedential. And that's not new. This actually arose a lot during the gay marriage litigation. Many courts enjoined their state marriage laws, and the Supreme Court simply denied a stay. And then the court said, "See, oh look, the court allowed the Ninth Circuit rule to go into effect. That's precedential." So for some time, people have treated these sort of shadow docket entries, either grants or denials of stay, as precedential. I agree with Steve on that front. I think that might be problematic. But the idea of that you have these urgent cases, we had a pandemic, with Trump. Right. We had a lot of chaotic things the last couple of years. And I told Steve this. I think his thesis was good for about a 4 or 5 year window. And it seems now things are quieting down. And there just are far fewer shadow docket entries than there used to be. But I don't know. We'll see what happens. I saw one other hand. Yes, over there.
Yeah, a little bit of thought on that case. You mentioned what in the case from I think last week.
Oh, that was, yeah, you mentioned this.
Calling on Bruin, calling constitutional law that requires skill numbers. On the question that the founding there were no zero sort of the platform. So looking at that kind of approach with looking at the deals on the fund stock, which we argue similarly to what fund stock is that the court has very
Yeah.
not logically proven going there.
Right.
Whitaker.
Oh, this kid knows his cases, right? Yeah. So there was a lot in that question. I'll try to just distill it a little bit more. You know, there were not many gun control laws in the 1790s as there are compared to today, right? They have a serial number, just wasn't known. They have an automatic weapon, just wasn't known. So when we have to ask ourselves, what is the analogy? You know, what would be, to use Heller's words, a dangerous and unusual weapon, right? Is this based on what's dangerous and unusual today or dangerous and unusual 200 odd years ago? I think the biggest challenge for judges with Bruin is the court seems to reject all means, ends, balancing tests, which is how common law has been done for a century or so. Do you have to go? I'll finish my sentence. And so the failure to accept any sort of means and balances leads to bright line rules, which is why I think you get a judge in West Virginia say you can't have serial numbers. I don't think that's going to stand. But the court, I don't think the court actually meant what they said in Bruin. I think they're going to walk it back over time. I think they're going to sort of dilute what they said.
Yeah, one of the things that's striking about Bruin is that the opinion seems to say you don't do even usual strict scrutiny analysis. Like even a compelling interest is not enough to outweigh to outweigh the right of gun ownership or gun use. So I think it sets up gun rights as the top of the rights pinnacle, the rights pyramid, and I think you're right. If there's no means ends testing at all, it doesn't give a lot of guidance to lower courts.
All right. I think Kent has to go. Thank you so much, sir.
Thanks, Joe.
Good on you. Thank you all. And I'm happy to answer any of the questions. He has our class in a moment. Thank you so much. We don't talk about Bruin. No.
I'm speaking with a barbecue sauce or maybe we feel great. No one else. Thank you.